Sono molto felice ed onorata di essere qui alla conferenza organizzata per Amedeo Postiglione. Mi piacerebbe poter parlare nella sua bella lingua, ma purtroppo non è possibile. Continuerò quindi in inglese sul tema the experience of the Court of Justice of the European Union in enforcing environmental law. EU legislation on environmental law covers most relevant areas in detail, in particular air, water, waste, chemicals, biodiversity and procedural aspects. Therefore, the European Court of Justice very often deals with environmental law. I would estimate that in the last 5 years about 12% of our cases, or that's around 300, raised issues of environmental law. Nevertheless, we are not specialized. The principle is that every member of the court does everything, fiscal law, social law, labor law, competition law, and so forth, and environmental law. Many measures of EU environmental law implement international agreements, for example, the Framework Convention on Climate Change and the Kyoto Protocol, the Aarhus Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters, or the Convention on Biological Diversity. Though these conventions are integral parts of the EU legal order, court cases typically are not directly based on these conventions, but on EU implementing measures. For example, the court has issued about 50 judgments on the Habitats Directive, which aims to contribute to the objectives of the Convention on Biological Diversity. Most environmental cases before the ECJ concern enforcement. I will discuss the two main procedural ways to bring such cases to the court. About 80% of our environmental law cases arrive by way of the infringement procedure, and most of the rest are introduced by means of the so-called preliminary reference procedure. First, on the infringement procedure. In general, the infringement procedure applies to disputes between the Commission of the European Union and the member states over compliance with EU law. The Commission is the guardian of the European Union law, and as the applicant in environmental cases bears the burden of proof. In cases concerning the practical application of environmental law, for example, the authorization of a road project crossing a protected site, such proof may be very difficult to obtain because the technical issues at hand are often very complex. However, member states are obliged to cooperate in the investigation of a case. Thus, in several cases, the Commission could demonstrate an infringement of the Birds Directives and the Habitats Directive by reference to environmental impact assessments prepared by the member states concerned. As far as the actual enforcement of EU environmental law is concerned, the procedure itself goes a long way to ensure compliance. It requests an intensive debate between the Commission and the member state in question. This dialogue aims to achieve an amicable solution of the dispute without the involvement of the court. In practice, this goal is often achieved. Most cases are resolved before they even go to court. Some more are resolved before the court issues its judgment. You may have heard of the Rospuda Valley case, an infringement procedure against Poland over a motorway project that should cross a very important wetland. Though the Commission introduced this case, a judgment was not necessary because Poland decided not to pursue the project. If judgments are rendered, they are usually implemented by the member states. Therefore, the enforcement procedure calling for monetary sanctions, as foreseen in the treaty, is rarely resorted to. Under this procedure, the Commission can initiate a second procedure before the court and apply to impose a lump sum or penalty payment on the member state. The first such judgment concerned the environment, namely an illegal landfill on the island of Crete. The second dealt with the implementation of the Bathing Water Directive by Spain, and another one with legislation on genetically modified organisms in France. Finally, interim measures should be mentioned as another instrument of enforcement. The Commission has obtained such measures in a number of recent cases, most prominently in the already mentioned Rospuda Valley case, but also in some bird hunting cases concerning Italy and Malta. Such measures can help to avoid irreversible damage to the environment while the case is pending in court. However, they require clear-cut cases and a speedy handling by the Commission. Let us now turn second to the preliminary reference procedure. The preliminary reference procedure provides for cooperation between member state courts and the European Court of Justice to advance the uniform application of European Union law. If national courts deal with cases that raise questions of European Union law, they may turn to the European Court of Justice to provide them with the interpretation of EU rules or to decide on the validity of EU legislation. It is important to be aware of the fact that in this procedure the European Court of Justice will not ultimately decide a case or directly enforce environmental law. The final decision remains with the national court. Therefore, the enforcement of any final judgment depends on the national court and the instruments available under national law. The European Court of Justice will only clarify the interpretation of Union law. Nevertheless, the preliminary reference procedure is of particular importance for the enforcement of EU environmental law. Theoretically, everyone who is a party to a national court procedure raising questions of EU environmental law potentially may come to the European Court of Justice. However, there are several hurdles to negotiate before such a question arrives at the Court of Justice. First of all the party needs to have access to the national court. A question of European Union law only arises if it can be raised in the context of the national court procedure. In principle, this depends on national law. However, European Union law grants rights to individuals which can be invoked in court. For example, under the directive on ambient air quality, member states must ensure that certain atmospheric pollutants do not exceed limit values in ambient air. If ambient air does not meet these requirements, the authorities must draw up an action plan to reduce pollutant levels to the parameters set by the directive. Under traditional German administrative law, it was thought that such plans would not be made in the interest of certain individuals, but in the general interest. Therefore, individuals would not have locus standi to require that the competent authorities draw up an action plan. However, the German Federal Administrative Court was not sure whether this position complied with European Union law and therefore referred a question to the Court of Justice. The court considered that the directive creates an unconditional and sufficiently precise obligation for member states to draw up an action plan. Therefore, the obligation is directly applicable and individuals are entitled to rely on it against public authorities. The Court of Justice further stressed that this consideration applies particularly in relation to a directive which is intended to control and reduce atmospheric pollution and which is designed, therefore, to protect public health. As a consequence, Germans can rely on EU environmental law to obtain results that they could not get under national law. Still, European environmental rights of individuals alone do not guarantee that the European Court of Justice can contribute to the enforcement of environmental law in national court procedures. Where an action is introduced, a reference will only be made if national courts are convinced that the question of EU law needs to be resolved to decide the case. Even if such a question is recognized, only courts of last instance are under an obligation to make the reference. Finally, European Union law does not provide individuals with a remedy if national courts do not comply with the obligation to refer questions to the Court of Justice. To conclude, the European Court of Justice has the procedural means to contribute effectively to the enforcement of EU environmental law. And on the initiative of the European Commission and of European citizens, the Court has successfully applied these means to advance the effective application of European environmental law. Regarding the future, one of the most interesting current developments is the integration of the Aarhus Convention into EU environmental law. As you know, one of the topics of the Aarhus Convention is access to courts in environmental matters. The Court has already stressed that the EU transposition of the Convention aims to ensure wide access to justice and to provide judicial remedies. Moreover, the Court has indicated that the implementation of the Convention requires clear rules to limit the costs of environmental judicial procedures. Moreover, currently cases are pending on the implementation of access to justice under the Convention. A central question concerns the extent of the substantive and procedural control available under the Convention. Thus, future interesting case law on enforcement of EU environmental law by the Court of Justice can be expected. Thank you very much for your attention.